Okay, so good morning to everybody who is in Colombia, and good evening to Dr. Hanan Mandel, who is 7 hours and a half ahead of us, who is literally on the other side of the world. On behalf of the Procedural Law Department of Universidad de los Andes, welcome to the webinar, Law and Technology in Courts and in Conflict Resolution, the Israeli Experience. First of all, allow me to extend the apologies of the Procedural Law Department Director. She's not here today because she's attending other academic responsibilities, but she said hi and thank you for being here today. Let me start by saying a few words about the Colombian context. Due to the coronavirus pandemic, the government issued the Decree AO6 with measures to implement information and communication technology in court proceedings. In general terms, there is a consensus that this decree has helped a lot to boost virtual justice, and there are currently several legislative initiatives to have a permanent law with the same topics. However, there's still a long way to go. There are challenges in technological infrastructure, in good practices, in filing, in evidence, among other issues. That's why I am delighted to present this webinar, which will provide valuable learning about what has been successful in Israel. The agenda of the webinar is divided into parts. The first one is Dr. Mandel's presentation for 60 minutes, and then we will have 5 to 10 questions to solve 5 to 10 minutes, to solve questions and to conclude. It depends if we are running out of time or not. If you have any question during Hannah's presentation, please write them down in the chat and I will make them at the end. Please don't forget to be concise. In this sense, it is an honor for me to present Dr. Hanan Mandel, who teaches law and conflict resolution. He writes about the use of technology in and outside the courts. He's a faculty member at the law faculty at Ono Academic College, which is the largest law school in Israel, and is also teaching at the Conflict and Negotiation Management Interdisciplinary Program at Bar Ilan University. Hanan is the chief editor of Democratic Culture Law Journal and the Hebrew Research Network at ssrn.com. He lives in Israel with his wife and he has 2 children. Dr. Hanan Mandel, thank you for your time, for being here with us. It is your turn for your presentation.
It's a pleasure to be here. I'm very happy to be with you. I just share the presentation where I start. And let me just start by saying that you are more than welcome to write comments and questions like Anna said, and I will try to answer them later when we finish our presentation. So don't hesitate to ask, to write in the chat, or to write or to raise a hand, and then otherwise at the end we'll give you time to ask. One of the few terms in English which was coined by people not formed by language is serendipity. Serendipity was coined by the English son of the first Prime Minister of England and a person of nobility by itself, Horace Walpole, which was the Earl of Oxford. And the term came from a story, a very known story. Origins are from Persia, maybe from Italy. There are conflicts between the historians, which was the exact source of this story. And the story is about 3 princes. sons of a king, which were raised to rule the kingdom, but when their father gave them the crown, they declined. They thought that the father is better than them. They didn't thought that they are ready to rule, so they declined. The father sent them away from the land, and then they were exploring other lands. One day, at the desert, they saw a merchant looking for his camel. And then they said to the merchant, "We saw your camel." The merchant said, it's not possible that you see my camel. They said, "Yes, and we will also tell you that the camel was carrying butter on one side, honey on the other side. The camel was blind in his left eye. He has one missing tooth. And also, a pregnant woman was riding the camel." He said to him, "How were you able to know that? You must be the man that robbed me from my camel. You took my camel," he told them. And he imprisoned them and sent them to the ruler of the kingdom that they were inside. Nobody knows that they are princess. And then the king is trying to give them a verdict at court. You stole his camel. And then the king asked them, "How were you able to know all these details?" So they told him, "We saw ants on one side of the road and flies on the other. Ants are drawn to butter, flies are drawn to honey. We saw that the grass was eaten only on one side. We saw a lot of evidence that led them to believe that they know about the camel everything." The king was very surprised by the wisdom, so he made them his advisors, and later they returned to their kingdom and became kings. That's a story. And Walpole told the story in order to coin the term serendipity. But by the way, serendip is Sri Lanka, Ceylon. It's that's in Persia, in Persian language. And the term serendipity means today that for sometimes you're looking for something, for one thing, and you find something else. If you are going on a way, it could be that you're looking for camel and you find kingdom. By the way, Walpole was changing the story from camels to donkeys because of the famous story of the Bible about Saul, which came to look for donkeys and find kingdom. And what's the connection between this term and our presentation? It seems that during the development of new technologies in courts, the courts were seeking for a way to be more efficient, more fast, and even more accurate. But at the end of the journey, we are going to find a completely different courts and also dispute resolution. And today, when I'm talking about courts, I will talk also about dispute resolution outside the courts, but I see the phenomena as one. Today, the court system and the ADR system are combined in most of the countries. And that's why I think that the first thing we have to do when we are talking about what is changing in the courts in Israel and abroad is the needs of the system. The civil justice system, whether it's the courts or the ADR, usually has 4 different problems: time, We want the decision to be as fast as it can be. Otherwise, we will say that the justice mill is taking a lot of time. Cost, the legal procedure is very costly, and we want it to be more cheap, so it could be more affordable, and people will have more access to justice. We want the decision to be precise. We want the court or the arbitrator or the negotiator or the mediator to have all the available information in order to be accurate in what he's doing. And we also want to keep civil rights like equality. We want to keep the people equal. So these four pillars also are causing the civil system to look for new technologies that will help her to be more fast, more cheap, more precise, and more equal. And if we are talking and trying to divide what is happening in Israel in this transformation, we can talk about three stages of revolution. The first stage is the stage that we are currently in, I think also at your country, not only in Israel. The first stage of the revolution is changing the way that the system works to digital form, via digital communication, through case management system. It is usually you underestimate the power of the first revolution. It changes a lot of things, and in a minute I will talk about and give some examples of how it's changing the courts and the civil justice procedures. The second revolution is the one that we see in Israel, we see it in the United States, we see it in Britain today. And the second revolution, which was unanticipated, is the revolution that sends the computer to learn law, meaning involving computers, or to be more precise, programs, to be involved in the justice system. They are helping the judges and the decision makers, other decision makers, to make decisions regarding the case that they have. It's an only system that support decision. The second stage of the revolution does not replace the judges, but the last phase of the revolution does change the judges. Meaning, the last phase of the revolution is the one that we see that instead of people making decisions, most of the problems within the civil justice procedure and applications will be done not by person, but by computer, by the use of AI, by the use of other systems, which I call them non-trial, that we'll talk about them later. Those three stages of the revolution are the roadmap to our presentation. I will start about the first stage of the revolution. What we see today is that instead of horses that are moving wheats from one side of the country to another, instead of people that had to go to the courts a few days distance and then stay near the court and ask somebody to help them to write, because most of the revolution didn't know how to write to the courts, how to read and write, and then go back to the house to the city, to the place, and wait for another messenger to come and tell them that the trial is set to 3 months ahead, and then to go when the trial starts and to bring the witness with you. This is a very problematic and costly and not fast way to manage the courts. Instead, what we see today is using the computer to exchange writs, to exchange all the papers needed in a dispute resolution. We also see a way of negotiating and making the deal in court through the judicial systems. We see the sum of the proceeding are done in remote. By the way, like you said, Anna, the COVID-19 epidemic caused a lot of countries to pass laws that move some of the court proceeding to be remote, to be with the use of Zoom, like we do today, to be with the use of Skype or other systems of remote meeting. But we see this phenomena of moving the court proceeding to the digital domain even before the corona. In the United States, we saw some of the court proceeding going to be by Skype 10 years ago. In Israel, we have some kind of court procedures that can be done by remote hearing 15 years ago. What you see in the little picture at the bottom of the slide is a famous comedian, Israeli comedian, which was accused of sending people to hurt the chairman of the television network that he works in and didn't want to prolong his contract. So he sent the violent people to hurt the chairman of the television network and another important manager, and they both were hurt. And the police find out that he was the one that ordered the action, and of course they jailed him and start a criminal procedure against him. But if they were going to bring him to court, it was problematic because all of the television networks were going to see this event. It was a very big event. Somebody knows to everybody, which was in every house, in every television, and then comes to the court. Everybody was there, and the court was fearing that he could not manage with all the people on the video. So they used a law which was in Israel already that permits the police to put the person which was in jail on television and transmitting the television to the court place. You can see even in the picture that the technology was not ready yet, meaning there was video and the video transferred correctly, but the audio didn't work well. So apart from seeing his picture at the court, he had to use telephone, a regular telephone, to move the sound. But in this way, they didn't have to move him with security to the court. And we see these kind of things at criminal procedure. In Israel, we saw it even at some of the civil procedure, for instance, proceeding about people who owe money. In Israel, we have a different system which is responsible for implementing court's decision, and part of the authority of this, like it's courts, but small courts, is to deal with people who went bankrupt. And instead of bringing those poor people to court and cause them more expenses, the law changed and permitted to make the court or the small court proceeding via remote video meeting. It's not only remote video. Another kind of the first revolution, another side of the first revolution, is the transferring to electronic reads. Instead of writing and printing and sending by fax, today all of the court papers in Israel are moved in digital form. You are not allowed to print a paper and bring it to the court. And there are some courts, small claims court, for instance, if you still can. And there are some procedures, for instance, people who are in jail can still use a written form like it was once used, because they don't have still the meaning to print and to send. Most of them don't have. But all of the other digital papers in Israel, in 99% of the civil procedure actions, are done by digital form. You must move it by email or by a special website, which I will talk about later. The change to electronic reads is important, not only because it decreases the time that the paper is going to be shown to the court and to the other sides. It's also important because it gives the sides more information about the case. You can analyze. If you have an electronic read, you can analyze it more quickly. You can use information in it in order to write your own papers. And you can use a search programs in order to find information which is usually hidden in a lot of papers. So electronic reads are more quick, they're even more accurate, more precise. Another side of the same first revolution are the change on the evidence. Today, and I assume it's the same at your country, most of the evidence are not witnesses. A lot of the evidence is what we call forensic evidence, whether it's chemical examination, whether it's using data system and getting allocation of people from the cellular network, and whether it's DNA or other kinds or fingerprints or other kind of information technology, which is used today in most of the countries to give evidence to the court. Not only a hearsay, but also a more accurate evidences. And you can see that we moved from the very primitive way of proving, which was trial by ordeal at the Dark Ages, towards a more scientific way of obtaining and presenting evidence to the court and other decision makers. These are the sides of the first revolution. I wanted just to give you two examples, one inside the courts and one outside the courts, to this revolution in Israel. And the first one is Net HaMishpat. Net HaMishpat in Hebrew means the legal net, the legal network. And Net HaMishpat is the official system of the Israeli court courts, which was launched at January 2007 and operates until today. It is not only a place where the lawyers and the sides have to deposit their papers. It's not only the system in which the sides are getting the decision from the courts. It's not only the system where the sides are getting of identifications about hearings, about decision, about important dates that they have to stand for them. But it's also a system which gives the court a lot more of information. One of the important parts of Net HaMishpat, a lot of money was invested in this side of the system, is called the dashboard. The dashboard is a page that each judge has that shows him what is going on his desk. What are the cases that are hanging before him? What is his schedule? How many cases are waiting to get a decision? How many cases are waiting to get a final verdict? How many cases does he have to order the sides? He can also press a button and move some of the decisions that he has to do to a new participants in the legal system, which in Israel is called the legal aides, or like in other systems, the legal clerks, and the legal interns, and the legal helpers, and a lot of new positions of people which are helping the court in managing his case. They are not deciding, but they are helping the court in order to manage the system. They can see also the dashboard, and they can help the judge moving things around. This is Net HaMishpat. By the way, the main criticism about Net HaMishpat, apart from a financial program which was at the start, like in every other governmental development, they gave an estimate of how the project will cost, but at the end it was not twice, 10 times more expensive. But apart from this, the main complaint about Net HaMishpat today is that the lawyers are saying, we are all day at the Net HaMishpat. It's not colorful, it's not lively, it's all in the same color. From time to time is slow. And we want a quick response. We are ready to press the button, and we want a response in a minute. And since it's on a website, it takes time. That's the main concern about the problem. Today, lawyers in Israel cannot think about working without Net HaMishpat. If you tell them that 10 years ago, 20 years ago, people were using faxes and using people on motorcycles in order to get papers to the court, they will laugh at it. Everybody has a smart, it's called smart stand, but the meaning is a way to be recognized by the system, that you be sure it's you. Everybody has this kind of little thing that you put into the computer, which helps you to identify yourself in the system, and that's all. This was what was done inside the courts about the first solution. I want to show you about also an important thing that was done outside the courts, also via the first revolution that we talk about. And I'm talking about a system which, by the way, if you want, you can find a law journal article about it, because one of my colleagues in Israel, Professor Ona Rabinevich Eini, wrote a complete article about this program. And the name is, in Hebrew, Benoam. Benoam means in Hebrew to be polite, to be nice. Benoam was invented in order to help insurance companies deal with car crashes. If you know, at least in Israel, I don't know what is happening at your country, but everybody who has a car must have insurance. The insurance is covering not only the personal injuries that can be done by car accidents, but also what we call in Israel aluminum claims, meaning all the parts of the car that were damaged during a crash. It doesn't have to be a crash with people involved. It could be that you entered the door of the car was scratched by something. It could be that you didn't park well, so some of the tires were hurt. But most of the people have insurance. And when something is happening, usually the insurance company asks you to tell her what is going on, and then you tell him who is responsible to your belief, and then the two insurance companies of the first car and the second car, of the people who were doing the injury and the injurer, are dealing with the stuff through courts, like it was before Benoam, which one will pay. And this kind of claims were taking the time of the courts, were a lot of money. It would be between companies. It's not between people even. So what the founders of Benoam decided to do is to invent a system which is giving the insurance companies a way to deal with the problems outside the courts, without the courts. And the system they designed, and I have to tell you that it was designed 20 years ago. I will tell you later that this system today doesn't work in Israel, and tell you why. But it was working for 15 years. And what the system was doing, at first it wasn't even in web, it was like the old digital computers that we had that were using like black and white forms on the computer, is that every insurance person had to input the claim into the system. And I didn't write like it was writing in the courts. Somebody hit the car and the car was hit. You had to choose between modeled answers. Which was the car? Choose between models. The damage was in the door, in the front, in the engine. You had to sign it, and then you have to upload pictures. And then you have to state what is the damage that the insurance company thinks that she wants to get from the other insurance company. After you input the case, both of the sides inputted the decisions, the system was making automatic counter offers, meaning both sides were able to present the computer, the system, the sum that they are willing to compromise on. And if the system was seeing that there is a close answer between the two offers, it was trying to get the sides to get counter offer which is close, like what we are doing if you have an automatic bid. Everybody has a few minutes to raise his proposal. If it didn't work and both sides were not close, then the next stage was moving into a personal mediator, which didn't meet with the sides because it takes time, only offered them a solution from his view after he saw the case. And the sides could agree or not. And if they didn't agree, it would go to an arbitrator, a regular arbitrator, and if not, and if the decision was not, and then it could be to an appeal at another arbitrator at the head of the project. most of the cases ended at the second or third part. None of them came eventually to an appeal, and most of them didn't come to an arbitration. The system was so successful that during one of the years, it controls 95% of all the insurance claims regarding car crashes in Israel. It looks like a small sum for each month, 350 million shekels. But if you're talking about Israel, which is a small country, it's a lot of money, and it's a lot of claims. Eventually, what killed the system, what the person who ran it stopped working with the insurance companies, is that the insurance companies find out, it started by they asked him that the sum is not done immediately after the decision, but it will be done quarterly, meaning the program is collecting the sum that each company owes another, and then in order to save financial transmission fees, it only does the transfer on a quarter of the year. And what the companies saw, that regardless what the decision were, they were moving money at the same amount each quarter to the other insurance companies. Of course, if we are talking about regarding the policies that they own, meaning a larger company usually was transferring more money, and a smaller company was moving less money. So at the end, 5 years ago, the insurance company said, I don't have to pay for the system. We can do an agreement in which at the end of each year, all the insurance companies are transferring money from one side to another with regards not to the crashes, but the number of policies that they own. This, by the way, is what I'm calling non-trial, meaning instead of a system which is helping the sides to resolve the disputes, they designed a system which does not have disputes. The new system does not have disputes. It's not regard who is responsible and who made the false thing. It does not matter. So this is the norm. Now we go to the second revolution. The second revolution, as I said, is you teach the court, you teach the computer to do law. It's not only done inside the courts. We have today in Israel 3 startups which are working on what is called smart contracts. I assume you heard about this kind of thing. Anna, did you hear about it at the course? Did you learn about it, about smart contracts? Do I have to explain?
No, it is my first time that I heard about it.
Okay, so smart contracts are an algorithm in which the contract is inserted into the algorithm, and then the algorithm itself can make the contract. For instance, if there are 2 companies that has a contract saying, when I send you this kind of merchandise, you have to return me this kind of amount of money. Then you form a program, an algorithm, which is getting the information from the storage department of the first company and the shipment processes, and also has control on money transfers from one account to another. They have a permission that the banks give them, of course, by the agreement of both sides, to enter the account. And then you don't have to get a lawyer and don't have to go to court and you don't have to do anything. You only have to run the program. The program is run. It sees the shipments. it sees all the conditions, and then he moves the money. This was called smart contracts, meaning the contract is done by an automated algorithm at a computer. It's more accurate. You can't fool it around. He sees all the information and does it automatically without a human hand. Also, we see at the second revolution also things that are happening in Israel. E-discovery. Courts demand evidences. Most of the evidences has to be shown to the sides before the trial in order to them to know what will be presented into the court. And this is a very costly process, the early discovery. And usually, if you are talking about what is happening in courts all around the road, it's one of the problematic phases of the proceeding. E-discovery means you don't transfer the information in papers or in meetings. You transfer it by digital form. In Israel, the early discovery is done by e-discovery. It's also in the United States, it's not only in Israel. Meaning courts demand that one side will send a big file to the other side. This file contains all the information. It is formatted in a certain way. And you can do whatever searches and fishing expeditions, like what was told in other days, into the files. The last side of the second revolution that I can talk about, which is still part of science fiction, is network decision making. Meaning that the computer helps people around the court system to collaborate and to make decisions. For instance, I was talking before about all the people involved in decision in courts in Israel today. The cases judges and fellow judges and registrars and legal clerks and even private agents which help the courts in all the things. What these kinds of system of network decision-making systems are doing is helping all the sides to exchange information and to make a decision. For instance, all the judges that are handling the case has to answer one question, and the computer is giving them what they decided, but in a more quick and efficient and accurate way. So this is the second revolution and the things on it. And I'm going, at the last 10 minutes of my presentation, to go to the last phase. And the last phase is the serendipity. It's what happens when you seek for programs to be more accurate and more fast and more cheap and more equal. And then you find at the end that people are not doing this very good. The judges and mediators and arbitrators will always be human and will always be errors, filled with errors. And they will all have biases. And we all have people that we like and dislike. And we all have people that we profile and think that are like we see them, and people that we think about not. But there is a process that is without humans. And it's better. It's more precise, it's more cheap, it's more accurate, and it's even more equal. This is human justice. This is the third revolution. The computer is transferred to be a judge. What we see today it's still on development. What we see start of this kind of things to be is programs that do the decision themselves. We see it, by the way, on what is called ODR, Online Dispute Resolution. If you went to AliExpress or eBay or Amazon at the last year, you saw that most of the resolution process today is done by computers and not by people. AliExpress stopped the workers for seeing disputes. Today, a program that knows to analyze what the seller and the buyer are writing is making the first decisions regarding case. You get an automated message that AliExpress says to you, we looked into the dispute, our computer looked into the dispute, and we want to offer this resolution. In most of the cases, you don't have to even to offer, meaning most of the sellers are doing agreement with AliExpress, saying if you decide that we have to pay till $100, you don't have to ask us. We approve it already. If there is a problem of a product that came damaged, you don't have to do anything. Just tell us at the computer, we'll send it again. And you see this kind of applications getting more and more close to the courts. When I was, I think, 20 years ago, at the start of my academic career, I was developing a program which was taking the rep sheet of criminal offenders that were already convicted at the court, and the only question was, what will be the number of years? What will be the punishment? What will be the sentence at the end? And what we did was letting the computer understand the rep sheet, meaning understanding what is the history of the offender, and he offered the judge insights that we find rep. And when first the program was starting, one of my jobs was to meet with judges and to show them the program. So with the first beta of the program was we're going to meet with one judge that he just this year passed away. And I know him personally, and I went to meeting with him. And I showed him the program, and I showed him, this is the rep sheet, this is the program. You see, I press enter, and then the computer says, according to our calculation, you must give this offender 5 years. The judge went up from his chair, took my computer, and told me, Hanan, get out from the room. I don't want to see this anytime. This is abomination. You want to say that I will be replaced by a computer? And by the way, we got when at the end of the process, we won a prize for the system, and we got a line of one of Israeli newspapers saying, "Will computer will be the judge?" And the answer there was no. We said no, it's only helping them. But today, these kind of systems are used by law. By the judges in Israel. The judge must use this kind of program in order to decide on the sentence. He decides, he has a lot of things to decide about, but at the end, his part will be only formal. What the program will say will be the important. Of course, there are a lot of problems with the third phase. Not only that we are losing the human touch, but also we are giving the kingdom to another person. The next king of the legal system at the first stage, at the first evolution, will be the programmer, will be the people who are making the programs and making the algorithms and making the AI. They are the true kings. The judge will be not important, the lawyers will be less important. And this is why the third evolution is still in process. We have a lot of learn about and think about. As I said, we see it already in Israel and other countries, but this is the future. We came to find a way to make the process more fast. At the end, what we find is a new king, the computer. And that's the end of my presentation.
Thank you, Hanan. Super interesting presentation. I don't see any question in the chat. Please, if anyone wants to ask something, please write it down. In the meantime, I have a question, and is when you were talking about the and I don't know if I'm saying it correctly, the Net
HaMishpat, yes.
Yes. So, did you start from scratch, or did you have like different softwares and then you unified them in one? Because in Colombia, like one of our problems is that like each court or each judge started it's like their own software. So now we have so many softwares that it is complicated to unify them. So how was the process in Israel with that program?
In this, I must have that you ask the right person, because I was involved in the development of Net HaMishpat at the start. Of course, like in your country, there were starting off very primitive softwares in different courts. For instance, we had before Net HaMishpat, we had in some courts a program which was giving numbers to the files, number and name, meaning maintaining a list of the cases, but not more than that. And when they started to think about Net HaMishpat, there were the decision maybe to develop only small programs and then to add another program and another program and to unify them at the end. The decision was not to do so. Net HaMishpat was one system from the start, and when he entered, in each court that he was entered, the staff was giving orders to wipe out any other softwares or Excel forms or access projects that people were doing in the court and start using on Net HaMishpat. What still happened in Net HaMishpat, and that you see it until today, it's still work in progress. At the start of the program, the dashboard that I talked about wasn't available. It was only a place to open cases and to get decisions. And the Net HaMishpat is getting a new version every few months, and each version contains one feature, and of course a lot of a lot of new bugs and old bugs that are common. But like in the software industry, you have bugs, but you have features, and every time you have a new feature. It's very important, because if you are starting with various different programs, usually you have to spend a lot of time on the information and interface between the programs. Mm-hmm. And in this way, you don't have it. Everything is inside the same database, and you only add more features, more screens, and more things that a computer does know how to do. Mm-hmm. So this is how it's done in Israel.
Yes, like the problems that we're facing is that in the interface, there are softwares that are not compatible with the other one. So yes, they are trying to figure out so what's next? What we should do to start a new one? And the thing with technology is that, as you said, it is evolving daily. So if you don't make decisions fast, then what you already decide is obsolete.
Yes, I have two stories about this. One is that indeed, one of the problems is usually it's also a technological problems. is to maintain the software compatible, because you don't have also only to mediate between one software and another, but you also to accommodate the application to the iron which is on the desk of the judge, meaning the system, Windows or another version of it, an Office, and they are changing rapidly. And you have to make sure that your program, the court program, will be compatible with other things. That's why Net HaMishpat is not done by an independent application, but on web. Meaning you don't have to change, because on web you can use it on Android, on Mac, on Windows, regardless of the interface, and you don't have a lot of compatibility problems. That's one thing. The second thing is also about my research. A few years ago, I was working on, I was wanting to get information about some aspect of the legal procedure in Israel. And I wanted to get information from the courts about how many cases were done this time. Of course, we write it in Net HaMishpat. And then I filed the request to get the information, and I got a denial. I asked why. You told me the information is available, and by law you must give. And said, of course, but what happened is that the company that won the government bid to back up all the things was replaced. And the old company doesn't want to give us access to the backup. And since we have to do your information from the backups, we can't give it to you. They told me to go to a person, I remember his name, they told me his name was Kobi Mushmush. That's his name. He is the one in the company that holds the backups. Try to convince him whether we will give you the backups or not. If we will give you the backups, we can give you the information. If not, not. So also in this kind of problems, there are usually this kind of problems, and it's very important.
Thank you, Hanan. So Nicolas, he has his hand up. Do you want to say something, Nicolas? Nicolas is one of my students, Hanan.
Very nice to meet Nicolas, but he is muted. So if he's talking, we don't hear him.
Okay, thank you. I couldn't activate the microphone myself. So I have two questions. The first is related to something that you were just talking about. How can a revolution in justice and technology deal with the challenge of the dependence that the justice system needs to have on private companies that produce software? And what are your views on the challenge of maintaining an independent justice system and a system that the state has power over it, when many of the challenges related to technology depend on the justice system relying on private companies that create these types of software? In the context of our elections, for example, which are next weekend, there are lots of questions about how the software we use for the electoral system is from a private company, and people make lots of critics based upon the idea that our justice system needs to be independent and we can't have private companies owning the system through which justice is made. And the second question is related to how to deal with the challenge of inequality, especially in countries where there's low internet access and low internet literacy. As I think that a justice system that becomes more where technology becomes more important requires for people not only to have literacy but also to have literacy in technology. And that's also, I think that's a challenge that we still need to work on. And I don't know, what are your views on that second challenge?
Both of the questions were very important, and thank you, Nicolas. I will start about your first question. There is a problem when you are giving private companies to develop things which are so crucial to the justice system. But I think that the problem of private companies that are working for the government is not only in the legal system. Usually today, armies are getting their weapons and their surveillance systems and other systems from private companies. If you are talking about even the way that the rate of the coin is determined at the central bank, it's done usually by a private company which they hire. And you have to give attention to the relation between the government and between those private companies. And indeed, like in some science fiction movies, the company can be so big and so influential that it will be even more powerful than a government. But as I said, it's not a problem that only related to the justice system. It's also related to the health system. By the way, most of the programs that we used by the government at the crisis of the COVID were private software. And Google was giving government access to their inside features, in order to understand how the epidemic goes inside the country. Meaning Google had more information about the epidemic than most of the governments, because she showed each government, each country only her data, but Google has all the data. So this kind of problem is related to regulation of technology and regulation of the private sector, which is very important. But as I said, it's not related only to software within the justice system. Though, of course, it's very important that justice system will be independent, very important that it will be unbiased, but still, you have the same problem when you hire a law clerk and you want to check his background, and it's not very unique to the legal system. Regarding your second question, which is also very, very important, I do think that one of the challenges in implementing the revolution in the courts is the rate of technology at the country, meaning how many wireless internet there are and how strong the signal is and how people have access to computers. It's important, but it's not the thing itself. And I told by a story, like I told before, not in Israel. This one, I was hired by the UN to help a project at India. And the project was aimed to give access to farmers which were mostly remote from the large cities and didn't have access to the courts. And the UN wanted to promote the access to justice in this kind of population. And what we did was sending a UN officer with a satellite phone and a computer, and he came to the people, and we wanted them to insert the claim. But what we didn't know, that most of them didn't know how to approach a computer, even though they had access through the computer had access through satellite connection. They didn't know how to write or to understand what is happening in the computer. So what we had to do eventually is to train the UN officer to help them, meaning he was the only one which was touching the computer. We thought about like something like you have in McDonald's today, about a place that everybody can go and press buttons and insert. It didn't work. So we had to place a people there, like it's a help, it's stuff that helps. And that will say them, you have to press here and you have to fill there, let me fill it for you. And still you had a problem. Still you have the technology behind it. Meaning even in countries that don't have this kind of access to technology, you can use the technology to increase the access to justice. You have to use the specialized things. In Israel, we have an ultra-Orthodox a community which does not use phones and does not use computers. And the government usually today is giving information through smartphones and through computers. So what they do, they hired a company, which was private company, by the way, which was translating the written information from the SMS message the government was sending to people who does have smartphones, and making them a sound like speech, like text to speech that you have, and then calling on regular phone the people, and they had the message delivered them by voice. It still was technology behind because it was computer doing this. But they find a way to get to the people without the connection, without the knowledge, without the access to this kind of technology. So I think there are ways to solve this very important thing that you talked about.
Thank you, Hannah. And I would want to make the last question, and is, we have talked already about several topics. In your opinion, which of them do you think the policymakers should focus on?
I mean,
we have talked about softwares, filing, like several technology developments. On which of them do you think the policymakers should focus on in Colombia? I know that you are not related with our legal system, but taking in account that we are not a super developed country. So, yeah.
I think the first and the second revolution is very important to you. You don't have to concentrate on the third revolution, meaning using AI, I think it's far from reach and will take time until it gets to you. But using a video conference, like you said you already have, and using case management system, and even using system which helps judge to make a decision and will help the sides to collaborate, meaning the second revolution, you can concentrate on those two. Meaning you have to concentrate on empowering the programs that you have, the system that you have, in order to have the first revolution, meaning transferring digital papers and remote hearing and so, but also already implement and develop the second phase, meaning software that will help the decision maker to make accurate decisions and fast decisions.
Okay. Thank you so much, Hanan. I don't know if there are no more questions, then it is the end of our event. Thank you so much for your time, for being here. It has been very helpful, a lot of interesting information to analyze it. We're making the right decisions. I hope to meet you soon, and have a wonderful night. And for our Colombians, have a wonderful day.
Thank you very much for having me. It was very nice to meet with you. I will be happy to meet with you again. And also you are invited to Israel, to visit Israel. It's a very beautiful country. And I was very happy to be here, and have a nice week.
There are messages in the chat. Thank you. Bye-bye.
In Israel, we say in Hebrew, we say shalom, which means peace. So, shalom.
Thank you. Bye-bye.
Bye-bye.